Hi, this is Lee from the Law School Toolbox. Today we are decoding legal Latin. In this episode, we will provide you with the meanings of various Latin phrases that are commonly used in law school classes. Our first Latin phrase is mens rea. The phrase mens rea means guilty mind. This Latin phrase is used in criminal law classes. Mens rea is the state of mind needed to convict a particular defendant of a particular crime. Related to mens rea is our next Latin phrase, Actus Reus, which means guilty act. Actus Reus refers to the physical acts or conduct needed to convict a particular defendant of a particular crime. As example of how mens rea and actus rea work together, in a theft case, the act of taking someone else's property is the actus reus, whereas the intent to permanently deprive the owner of that property is the mens rea. They combine to form the complete elements of a theft crime. Our next phrase is caveat emptor. The phrase caveat emptor means let the buyer beware. This phrase comes up in contract law and property law classes. Caveat emptor is a principle that places responsibility on the buyer of property or goods to perform due diligence. For example, inspecting the quality and suitability of the property or goods before making the purchase. Our next Latin phrase is res ipsa loquitur. The phrase res ipsa loquitur means the thing speaks for itself. This Latin phrase is used in torts classes. Res ipsa loquitur is a legal doctrine that allows a plaintiff to prove negligence even though the precise circumstances leading up to plaintiff's injury are unknown. The doctrine suggests that certain events would not occur without negligence, and therefore the mere fact that they happened implies negligence, such as a heavy object suddenly falling from the sky and injuring someone. Our next phrase is ultra vires. The phrase ultra vires means beyond the powers. This legal phrase is used in corporate law and administrative law classes. Ultra vires refers to actions taken by a corporation, government, or other legal entity that exceed the scope of power and purposes given to it by laws, charter, articles of incorporation, or other foundational documents. Our next Latin phrase is prima facie. The phrase prima facie means at first sight or on its face. Prima facie refers to evidence that is sufficient to prove a particular proposition or fact, unless disproved or rebutted. For example, if a plaintiff represents a prima facie case in an employment discrimination lawsuit, it means the plaintiff has provided enough evidence to support the discrimination claim, and the burden then shifts to the defendant to refute that evidence. Our next phrase is habeas corpus. The phrase habeas corpus means you may have the body. Habeas corpus refers to a legal principle that protects an individual's right to be free from unlawful detention. If someone is detained or imprisoned, the person can file a writ of habeas corpus with a court challenging the legality of the detention or imprisonment. If the court finds that the detention or imprisonment is unlawful, the court can order the release of the individual. Our next Latin phrase is res judicata. The phrase res judicata means a matter already judged or thing decided. This phrase is used in civil procedure classes. Res judicata refers to the principle that a final judgment rendered by a court of competent jurisdiction is conclusive upon the parties in any subsequent litigation involving the same cause of action. The doctrine is designed to prevent the relitigation of cases and issues that have already been decided. Our next phrase is pro bono. The legal phrase pro bono is derived from the Latin phrase pro bono publico, which means for the public good. In the legal context, pro bono refers to legal work that is undertaken voluntarily and without payment, or at a reduced fee as a public service. Our final Latin phrase today is stare decisis. The phrase stare decisis means to stand by things decided. Stare decisis is the doctrine of precedent. Under the doctrine of precedent, courts are obliged to follow the holdings of prior cases when making a ruling in a similar case. There is both vertical stare decisis and horizontal stare decisis. Vertical stare decisis is the principle that lower courts are bound by decisions of higher courts within the same jurisdiction. Horizontal stare decisis is the principle that courts, especially higher courts, generally follow their own prior decisions. The phrase stare decisis frequently comes up in United States Supreme Court cases when the Supreme Court is evaluating whether to continue to follow the holdings of a prior Supreme Court case. Thanks so much for watching. Be sure to give us a like and leave us a comment and to subscribe so you don't miss any future content.